Okay, yesterday we did the Catano conjunctive test, which is a weapon has to be dangerous and unusual, that language from the statute of Northampton, to be disqualified under the protection of the Second Amendment. And then 2 days before that, we did the first part of the Heller test. And so the Heller test is you're either qualified or disqualified from the exercise of your Second Amendment rights, okay? For us in New Jersey, we've already done that part. So if you have your 2C58-3B firearms identification card, you're already qualified to exercise your Second Amendment rights. And there's more to it than that, and we'll get on with that later. But right now, we're going to do the third test, and it's probably the most important test, and it's known as the Miller test. Now, there's two parts to the Miller test. It's critical to understand you don't have to meet both parts of the Miller test. You can actually meet one part of the Miller test or the other part, not both, because they're a little bit different, even though they both concern the efficiency of a well-regulated militia. And so it's not, they don't spend a lot of time on the Miller test in Bruen, but they are going to use the catchphrases from Miller, because Thomas alludes to the fact that they've addressed this already in Heller. And so in Heller, they addressed it at 28-14, and I think it's 14, 15, and 16 that they discuss the Miller test, and they're actually arguing with the dissent. And what's very interesting to note is the main argument of the government and the main argument of the dissent is that the Miller test is actually real and that the weapons are covered, but the argument is only the government can use them. So that's very interesting, right? Because as soon as Heller determines that the right to bear arms is an individual right, the government, and when I say the government, I mean all of them, the federal government and then the anti-Second Amendment state governments get away from Miller and their argument about Miller as fast as they can, because they were like, yeah, these weapons are good militia weapons, but the militia was the National Guard. That's the problem for the government now, is that by adhering to that argument and losing it in the beginning over individual rights, they basically said every single thing is on the table. And when I say every single thing, there are going to be limits, but they're really, really broad limitations. So let me just explain that when I say it, okay? So let's just touch on Bruen really quickly, because in the very early stages of Bruen on page 2119, it says petitioners Koch and Nash. It says it is undisputed that the handguns of Koch and Nash were in common use today for self-defense. And when I say today, I mean June of 2022, but it applies, the same logic applies today, okay? So I'm actually going to read to you the first part of the Miller test as it's stated in Heller on 2115, okay? I'm going to put my glasses on and read it, because I think it's important for you to hear the exact words from Miller, okay? So I made a couple notes, and I'm just going to read from the notes. In the absence of any evidence tending to show that the possession or use of a short-barreled shotgun, and let's just take that out and change short-barreled shotgun to weapon. In the absence of any evidence tending to show that the possession or use of a weapon at this time has some reasonable relationship to the preservation or efficiency of a well-regulated militia, we cannot say that the Second Amendment guarantees the right to keep and bear such an instrument. So that's it. That's Heller, 2815, citing Miller at page 178. Now, the court goes on, right? So they throw their Miller citations, and then Heller reads like this. Certainly, the court continued, it is not within judicial notice that this weapon is any part of the ordinary military equipment or that its use could contribute to the common defense. Okay? So let's change what the court said. Absent any evidence, okay? And so let's change that sentence around. All right, we're just going to drag and drop pieces and throw an ellipsis in here and an ellipsis in there. This is what it says. Any evidence tending to show that the possession or use of a weapon at this time has some reasonable relationship to the preservation or efficiency of a well-regulated militia, the Second Amendment guarantees the right to keep and bear such an instrument. What does that mean? Well, what that means is this, and I've talked about this before on Gun for Hire Radio on episode 448, but what that means is all you have to do is show a branch or division of the military that uses a certain weapon. And if they use it, that becomes an allowable militia weapon. Okay? And Sandy Berardi asked a question on Gun for Hire, and I think it's an important question. Does that apply to other government agencies? And I think, yes, 100% it does. So if your police department is carrying a Glock, you can carry a Glock. If your police department is carrying a SIG, you can carry a SIG. If your police department is carrying 9mm, you can carry 9mm. So we don't have to get into all the variations, because I think, whatever gun that you bought with your 2C58-3A permit to purchase a handgun, we could pretty much take that gun and find someone that uses it, okay? Now, some of you guys might be like, well, what about my Smith & Wesson 357 revolver? The military doesn't use that. That's true, and we'll get to that. What about an outlier, like a 454 Casull or like a 50 Desert Eagle? I wouldn't personally want a 50 Desert Eagle, but we can make the case that it is a covered weapon under the Miller test. Now, not in that first part of the Miller test, because you're not going to find any branch of the military or police department that's carrying a 50 Desert Eagle or a 454 Casull revolver, right? You're just not. And no police department's carrying, a Smith & Wesson 686 and 357 Magnum anymore. They're just not. That doesn't mean it's not covered, okay? So let's get to the second part of the Miller test. So in the second part of the Miller test, so this is page 179 of Miller, and this is also in Heller in that 14, 15, 16 page range, 28, 14, 15, and 16 page range. Okay, and I'm going to read that one for you too, because I think it's important that you get the Supreme Court's wording instead of my take on it. So let me put my glass on and just read that for you. We think that Miller's, quote, ordinary military equipment, unquote, language must be read in tandem with what comes after. Quote, ordinarily, when called for militia service, able-bodied men were expected to appear bearing arms supplied by themselves and of the kind in common use at the time. The traditional militia was formed from a pool of men bringing arms in common use at the time for lawful purposes like self-defense. In the colonial and Revolutionary War era, small arms weapons used by militiamen and weapons used in defense of person and home were one and the same. Okay? And so that's the second part of the Miller test that I think will get you your Smith & Wesson 686, your J-frames, your 50 Desert Eagle, your 454 Casull in common use at the time. So if the licensed firearms vendor sold it to you, then it's covered. Of course, in the middle of this, I got to do the low battery thing. If you bought it legally, it's covered. Okay? And so that's the Miller test. Now, very interesting. The Miller test here overlaps with yesterday in the Catano conjunctive case, dangerous and unusual, right? So in common use is the opposite of unusual. So in common use, non-unusual, those are synonymous terms, right? So the Catano conjunctive case even though the terminology is different because they're arguing something different, right? In Heller, they're arguing that the militia is the National Guard and it's a collective right. In Catano, now they're arguing that the 1328 statute of Northampton allows the government to ban dangerous and unusual weapons. And then in Catano, they compare this Jamie Catano's stun gun actually to revolvers and modern day handguns. And I think they said they would be unknown to the founders, but that doesn't mean that they're not covered. And that's how they arrived at the Catano decision. So the Miller test is super important for you to understand and explain it to somebody, especially, not just with this Bruen response bill, but as we start to move forward with these stabilizing brace. For us in New Jersey, it's other firearms. And I really think in New Jersey, we should be allowed to have an AR and AK pistol, a stabilizing brace, 8 to 10.3 inch barrel pistol, because we could clearly show that an arm brace AR other with a 10.3 barrel is exactly the same as the military's MK18 Mod 0 rifle. Same, everything on that is the same. The difference is one has an arm brace and one has a stock. And I don't think if we're gonna do Hellers at the time of the founding that anybody in the government can find an analog from 1791. And I don't think they can find an analog, let's say from 1774 to 1791, where the required militia equipment had to have a barrel length of over 16 inches. It just didn't happen. And so we can start to apply the Miller test in various uses, because it doesn't matter whether you're in a restaurant. It doesn't matter whether you're in a sports complex. It doesn't matter if you're in your car. If the weapon is in common use, or if the weapon contributes to the efficiency of a well-regulated militia, aka the military used the same weapon, then it's covered under the Second Amendment. And then they can't say, well, you can't carry it here. Which is kind of interesting, and I wasn't going to get into this, but it just popped into my head, especially for us in New Jersey, because, I keep saying Washington was absolutely begging Governor Livingston to send out the militia, and in those letters to Livingston, he's begging Livingston to make sure that the militiamen show up armed, and he's begging Livingston to make sure the militiamen show up with ammunition. And so, I've talked about this before in Gun for Hire 448. That's why we have Article 1, Section 8, Clauses 15 and 16 in the Constitution now. But the whole point of why I got there is, one of the major battles, one of the major turning points in the Revolution is the Battle of Monmouth Courthouse. And so Washington's literally begging guys to show up for the Battle of Monmouth Courthouse, and yet now we're in this whole debate over what a sensitive area is. Quite frankly, at the time of the founding, and I'm going to go 1774, right, from the circular letter from Dartmouth to all the governors in the colonies banning lead powder and weapons without a license from the king or his privy council. From that day until the Bill of Rights is ratified, you're just not going to be able to find a sensitive location like New Jersey's trying to create them. So New Jersey's just using guns are dangerous in a different phrase, but they're never going to be able to get away from contribute to the efficiency of a well-regulated militia, and they're never going to get away from in common use. And so as long as that in common use is used for the core lawful purpose of self-defense, they're covered everywhere, okay? And that's why it's important that you know what the Miller test is, because once you can establish that the weapon is covered under the Second Amendment, and then you go to the Heller test, and you establish that you're qualified to exercise your Second Amendment rights, then all of this other Bruen response bill that New Jersey's trying to do just becomes nonsense, right? They're trying to create laws that never existed and circumvent the Second Amendment and actually the Miller test and the Heller test. All right, I hope that helped. That's the third one. There's a couple more. There's a McDonald. I'd call it the McDonald rule, not the McDonald test. We'll get to that one next, and then we'll circle back and we'll hit the second part of the Heller test. Okay, I hope it helped. J Factor, New Jersey Firearms Owners Syndicate. Thank you.